Okay, thanks. Okay, well, we're going to now move on to the next panel, which is one I was particularly looking forward to. In fact, I asked for. It's on liability management. Over the last couple of years, I've been around for a while, and all of a sudden the term liability management has become like a forced, almost trademark concept of life, and I've had to deal with it at the feet of Alex and other people on this panel. So we put together a panel to talk about the concept and what it means to talk about liability management, and we're lucky to have some of the people who've helped formulate, create the concept and have really mastered it. I'll just get off and I'll turn it over to my partner, Mark Heblen, who specializes in bond defaults, representing indentured trustees, and has worked on some very big case over the years, including Chesapeake and Hertz. So Mark, take it away.
Okay, thank you, Harold. Good morning, everybody. I'm going to introduce our panelists, but we have a lot to cover, so I'm going to keep the introductions short. Suffice it to say that they're all really impressive with really stellar credentials. First to my left is Alex Schwartzman. Alex is a restructuring partner in the Chicago office of Kirkland & Ellis. She focuses her practice on all aspects of corporate restructuring, bankruptcy, and insolvency, and was recognized in chambers as exceptionally bright, accessible, and client-focused. See, I told you, very stellar credentials on this panel. In addition to Chesapeake Energy, which we worked on together, she's worked on cases such as Exco Resources, Lynn Energy, and Sabine. Next is Christian Temke. Christian is a managing director in the restructuring group at Lazard, which he joined in 2007. He counsels public and private companies and creditor groups in complex restructurings, sales, and capital raises in a broad range of industries in North America, Asia, Europe, and South America. So he's conquering the world one continent at a time. Next is Harrison Denman. Harrison is a partner in the New York office of White & Case and a member of the financial restructuring and insolvency practice there. He previously clerked for Judge Peck and was named an outstanding young restructuring lawyer by Turnaround and Workouts. His notable engagements include Caesars, Sun Edison, where we had the pleasure of working together, and iHeart Communications. Next is Ian Silverbrand. Ian is a vice president in the distressed products group at Goldman Sachs, and before that was at White & Case. He is a restructuring and credit attorney who has worked as an investor and an advisor to credit and PE investors. He has significant experience with distressed credit, private equity, and litigation investments with an emphasis on legal and process-oriented solutions. And finally, we have Mark Kalla. Mark is a senior vice president at UMB Bank in Minneapolis. Before that, he was a partner at Dorsey & Whitney and Barnes & Thornburg, among other firms. At UMB, he works on corporate and municipal bond defaults and bankruptcies when UMB is serving as an indentured trustee in those deals. So that's our panel, and like I said, we have a lot to cover, so I'm just going to kick it off with a question. And I think my main thing to do here is just get out of the way, and I think this will be an interesting discussion. So let me kick it off by asking Alex and Christian, what is liability management and why do borrowers engage in it?
Thanks, and thanks for inviting us to be here. I actually think that Stephen had a perfect slide to explain what liability management is when he was showing Delta's stats, and he was pointing out that the Delta CFO has done a great job of reducing balance sheet liabilities and increasing cash. And that is liability management. When you don't have access necessarily to traditional ways of reducing your debt or increasing your cash, it's figuring out how to manage your liabilities. It is not the dirty word that I think it's become in our industry as of late, but it's really just helping your company figure out how to get from A to B when some of your normal routes are not open to you.
Yeah, and the type of transactions you see, could be really twofold. One, there's one set of, I would say, more opportunistic type of transactions where, there's not necessarily a restructuring catalyst on the horizon, but there are opportunities to delever, to capture discount in the debt or the like. And then on the other hand, you could face, or companies could face, maturities that come up in the next 2-3 years. Companies with liquidity shortfall on the horizon and the like. or covenant issues. And so it's really about proactively addressing these type of issues in the context of out-of-court transactions. And so, liability management transactions, when people talk about them, could be as simple as, debt repurchases at distressed prices in the open market or block trades. Or alternatively, sometimes you have more complex transactions. Those are the ones that, get the headlines more, sometimes get challenged, where companies, need to find creative ways to extend maturities or raise new capital. And there you would have like up-tier exchanges, you have asset drop-downs, where, part of that transaction is being used to basically create some currency to transact.
Okay. And so you mentioned asset drop-downs. Can you just that may be a term that everybody understands, but can you talk about what happens in an asset drop-down, for example?
Yeah, sure. So to name a few examples, so similar to transactions like what J. Crew has done or Neiman Marcus, certain assets are basically moved or transferred into unrestricted subsidiaries that are created, and then they create basically an asset that can be utilized to either raise new financing against it or could be used to do an exchange of existing debt against new debt at that entity. And so, transactions like that where, as I mentioned, J. Crew back in 2017, when they moved a portion of the IP into an unrestricted subsidiary, or Neiman Marcus when, it moved, My Teresa into an unrestricted subsidiary. And then, that's only a portion of that transaction, but it can facilitate the overall negotiation to achieve, in Neiman's case, it was, an amend and extend of the capital structure to buy Neiman, additional 2-3 years time to implement its turnaround plan.
And so, how do you approach and structure transactions when you're brought into one of these? What's the first thing you guys are doing with your client?
Yeah, I think there's a few things, but the first is you need situational awareness. You need to understand what's the company's outlook, what's their plan, what's their business plan look like. That's obviously something that Christian and the bankers get more involved in helping diligence. And then you need to do a really deep dive into the credit documents to say, okay, well, what are your options? And when you know what the goals are and you know what your options are, then you can start to figure out, okay, here's various different transaction structures you can start to contemplate. And so I think it's incredibly fact-specific, right? It depends on what your documents allow, what sort of capacity do you have to structure these types of transactions. What does the creditor base look like? Do you have very concentrated holdings amongst a couple large institutions? Is your debt very widely held? What's the likelihood of getting some sort of anchor tenant for one of these transactions to support it? You're going to have to go out kind of blind and offer up some sort of exchange and just kind of see what's out there, what the appetite is. All these different factors will go into the calculus of what do you ultimately recommend to a board or put in front of a board. And then, of course, I think really importantly, these transactions need to be a step to somewhere else. You're not just building a bridge to nowhere. Liability management transactions are, a step on your way to greater financial soundness. And I think that's really, really important. So then if somebody does attack it down the road, you weren't just moving value to a new subsidiary away from creditors for no good reason, no goal in mind, no potential path to being able to stave off a more formal restructuring. And so all those different factors come into play, and that's a lot of what we talk about in the beginning.
Yeah, I think understanding the business plan and the forecasts that management create are important. They ultimately going to define, what the balance sheet, should look like, or what the cash flows can really support in terms of the amount of debt that exists on the balance sheet. And so, the questions that the board, is considering is basically, does additional time if there's additional time that can be created through, let's say, an extension of the capital structure or raising additional capital, can the company, based on reasonable forecasts, grow back into the capital structure over time? Even if it's either a turnaround plan that's being implemented or to wait through an industry downturn like you've seen in the oil and gas patch. And so some of those questions are pretty important up front to debate, and we help the boards understand the pros and cons of different alternatives as they approach these type of transactions. The other element that's interesting and I think often is misunderstood, I mean, these type of transactions are really more viewed as opportunistic and early stage. So it takes a lot of time to develop the right, I call it like playbook of different alternatives or structures. And then it takes a lot of time to negotiate these type of transactions. And so, what you don't want to end up doing as a company is, get caught halfway through a transaction and basically face a catalyst of running out of money or facing the maturity, because at that time you don't really have, the options available to you anymore to pursue these type of transactions. And so often, the board and the company would or should consider these type of transactions, I would say, like, a year, 2 years, 3 years in advance of upcoming catalysts, to make sure that that alternatives exist at the time of the transaction.
I know each situation is different, but when you're advising the board and management at this point, is the B word being thrown around, the bankruptcy word being thrown around at this point, or is that still off into the future a little bit?
I think it probably shouldn't be. I mean, these are the types of transactions you're undertaking to avoid a bankruptcy. And I think if, a bankruptcy is really on the horizon, then these aren't necessarily your best options. No blanket rules, but that's kind of how I think about it. So often when these liability management transactions show up in the cases that we work on, they're sometimes transactions that happen, multiple years in advance of a filing, not necessarily something that the restructuring professionals were involved in, but they become a target of litigation because, of course, the first thing that I think creditors and creditors committees look at when they're trying to assess potential pockets of value and leverage and negotiations throughout a case is, what's my litigation leverage? And so people go back and they take a look at these types of transactions the same way people would take a look at an LBO that could have happened, 5 years before the filing, and they'll go back and they'll say, well, obviously you were insolvent for the last 5 years, and that sponsor should have to give back all the money. And so, no, I mean, I don't think they necessarily go together, but we see them together because of the way it plays out in litigation and bankruptcy.
Okay, and then once you've developed this strategy, what you think you want to do, what comes next, and how do you get this deal done?
Yeah, sure. So typically after you figure out the right strategy, you help develop a term sheet that could be rolled out, and then it really depends on the type of transaction that you're trying to pursue. So if it's more opportunistic, where you want to, let's say, capture discount in the bonds, but you have only a certain amount of capacity to do it, you try to figure out who your anchor tenants are in the capital structure, larger holders, and you would approach them and present a term sheet to them, and then you negotiate around the term sheet, and hopefully you get to a deal. In transactions, and in those transactions, often the holders don't have, the specific holders don't necessarily have bankers and necessarily restructuring counsel involved. I mean, gonna get involved, but those are more the opportunistic type transactions. I would say in transactions that look a lot more like a broader out-of-court restructuring or recapitalization, they function very similar to the more restructuring type transactions where each creditor group has counsel and advisors lined up and hired the creditors organized. Because in a maturity extension, you want to try and get as many participants as possible. So it really becomes, very similar to, from a process perspective, similar to an in-court restructuring where, the advisors do diligence at first, and they get their clients kind of restricted, and then you negotiate the deal, and hopefully you get to a successful outcome. So it really is situation dependent on how you approach them.
Are there any deals you two can discuss either by name or just generally that where you've gone through this process and what happened?
Sure. I mean, two off the top of my head more recently, one with CWT Carlson Travel, which we just filed. They did some liability management transactions at the very beginning of the pandemic, which we talked about in the public filings, and I think were public knowledge at the time, and they were basically pushing out maturities. There was some up-tiering that happened as well. And that was, a situation where you're looking at the pandemic. Everybody thought it was going to be sort of short-term in the beginning. This is not a company that necessarily needs to file for bankruptcy if this is going to be like a blip on the radar. And they engaged in those, and then lo and behold, a year and so goes by, and obviously this is not a short-term issue. This has now become a much longer issue, and a more formal restructuring was needed. So in that circumstance, you do see the liability management and the formal restructuring fairly close in time, but that I'd say is, I don't know if it's an outlier, but obviously very situational. Nobody knew at the outset what we were facing. I think if people had known how long the pandemic was going to last, I don't know if there would have been two series of transactions or just one. And then one where it ended up in a much more litigious posture was Chesapeake Energy. And that's a company that, sort of good CFO stewardship, they had been reducing their liabilities, I think, by about 50% over the course of 7 or 8 years, from like $20 billion to $10 billion at the time we filed, through hundreds of different liability management transactions. And one in particular that happened in December of 2019, we filed in June of 2020, got a lot of airtime in court. And again, this was really sort of a litigation posture to try to drive more value for recoveries for unsecureds. But the people who participated in that transaction, there was up-tiers, there was new issuance of debt, there was extended maturities, there's all sorts of different elements that we talked about, and some anchor tenants. And then it became the topic of like a month-long trial at the end, which I think people saw play out.
Well, the one I can add to that is on Transocean, the transaction, oilfield service company, and not surprisingly, similar to a lot of the competitors, a lot of distress, and the debt was trading down, to like the 30s and 40s, multi-billion-dollar capital structure, a lot of unsecured debt, and ability to do, up-tier exchanges and the like. In that transaction, it was a series of different transactions where unsecured bondholders were offered more structurally senior debt that was guaranteed by some new subsidiaries that were created. So it was a first step of an internal reorganization that happened to create the structure to offer the new consideration. And then there was first a private exchange that was launched with subsequent, follow-on public exchanges. Overall, the company was able to push out maturities. The near-dated ones created, I think they pushed out over 60% of their near-dated maturities. They captured over $1 billion discount in the debt as part of these transactions. And interestingly, too, some of the holders that were not participating in the transaction were challenging the transaction and the validity on some of the internal reorganizations and the like, and try to block part of the exchange. Ultimately, I think the company was able to complete the exchange and get rulings in favor of doing so.
Great, thank you. That's a good segue, actually. Thank you for giving us kind of the company's perspective on these transactions. Ian and Harrison, can you talk a little bit about how investors view these transactions? I imagine that sometimes you're involved in deals where, or representing clients where they're in favor of these transactions. Maybe sometimes they're vehemently opposed, and maybe sometimes you're representing new money coming into a transaction, so like this. So give us some insight if you can from that perspective.
Sure. So it's interesting from the creditor perspective. It's a slightly different analysis. I think what you heard is from the company side, it's about getting from A to B and fixing the problem and finding a clever way to do it. I think from the investor side, it's much more opportunistic. It's trying to diagnose where the company needs to go and trying to figure out a way to help them get there, and all the different things that come off of that. I think one thing you'll hear as Ian and I go through it is it hinges a lot. The creditor and the investor approach hinges a lot on whether it's an offensive or a defensive posture. I think that's going to inform the risk calculation, and that's going to in turn inform all the proposals that you're willing to submit or participate on. Ian, I don't know if you...
You hear me through the mask, or should I take the mask off? We'll try to keep it on. I guess I would just add that for the most part, distressed credit investors are rarely surprised when these types of transactions happen. I think distressed credit investors have gone through enough of these types of situations where they've felt pain in liability management exercises to realize that analysis of credit documentation and what can be done to you or for your benefit is an integral part of your initial investment thesis. I think investors now all have the benefit of covenant review, reorg covenants, outside counsel like Alexandra and Harrison to inform your views on what can be done or what can't be done. And I think sort of having a view of the limitations and of your investment documents helps inform your views on sort of how to posture yourself within a given investment.
So, if you think about it as an offensive or defensive kind of construct, I mean, offensively, the way the investor would approach the situation, you try and identify the distressed credit, as Ian points out. Those are all pretty much known to the industry at the moment at which they're embarking on that, and trying to diagnose what might be enticing to the company in terms of what kind of proposal, what the documents might permit. There's always a little bit asymmetry of information, especially at the beginning of the conversation. But still, there's resourceful ways of kind of working through that to try and deduce what's permitted under the docs and what isn't, and ultimately formulating a term sheet and submitting it to the sponsor or the advisors. I think that kind of offensive scenario where you're maybe not in the debt or you're in the debt small and you're submitting something on your own initiative, those are kind of low probability events. It's difficult to prevent the sponsor or the company from shopping whatever you submit, and the world of scenarios where you as the pitching investor have something unique that you can bring to the table. If you're not an already existing big holder in the structure, that's kind of limited. Alexandra mentioned CWT, and I was thinking that's a perfect example where we were representing a fund, and we came in relatively cold. We just submitted a proposal along the lines of a planned sponsorship that we thought could work under our docs. The company, as you heard, they reached an agreement within their existing creditor base, which is a much more common way of pursuing it. Ian, I don't know if you want to add to that.
Yeah, and I think I think if you're an existing investor, one thing you're sort of thinking about is where you are in the capital structure. If you really have an aggressive long-term view of the company that's pretty favorable, you're probably more likely in a more junior tranche position within the capital structure, and you're probably looking at your documents thinking about what value already exists for me that's unencumbered, what can be done for me as an asset drop down or an exchange into unsecured or an exchange into an unrestricted subsidiary. Whereas if you're perhaps more conservative, I'd say you're probably more focused on how much liquidity can the company raise around me, how much dilution can there be, how much collateral leakage can I anticipate. And I think when you're thinking about in, say, a CWT, and you're trying to come up with a proposal, I think you're sort of trying to navigate all of that and find the right spot for an instrument to come in.
So Harrison, Alex and her colleagues aren't talking bankruptcy at this point when they're doing these transactions. How about you? Are you talking about a potential bankruptcy when you're involved at this point?
Yeah, we are. And it's funny, I made a little note that I wanted to come back to it. That is, front and center on what they're thinking. From both sides, some of it could be opportunistic. They need to vet the liquidity profile and make sure that whatever they're providing and whatever they're restructuring is sufficient to keep them out. Some of it may be more offensive. You may be thinking ahead to what the bankruptcy would look like, and who controls coming out of the LME, who controls the dip rights and cash collateral consent rights, things like that. If it's a drop down, if the assets are being segregated, there's some strategic benefits to having the new paper that is uniquely accessed to certain assets. The example that came to mind with that was Claire's. In Claire's, you had the sponsor facilitate the drop down of some IP assets, and the sponsor then participated in the loan, in the LME loan to the IP co. The result of that is that if there's bankruptcy, and there was, a year later or 2 years later, the IP is segregated in a box that the sponsor controls regardless of the overall debt stack, right? And that has real consequences in the bankruptcy.
Okay. Anything else to add on the investor perspective?
Yeah, I think whether it's offensive or defensive, I think when you're approaching the negotiations of the documents, this was something we wanted to cover. The opportunity to improve or control the documents post LME really only exists if you're one of the anchor investors / lenders. If you're sort of part of the group but not driving it, or if you're outside of the group altogether and participating or not participating, your ability to input on the docs going forward is pretty limited. That's usually pre-baked by the anchors on the company, and I think that's just one of the overall factors that would counsel in favor of joining the negotiation and trying to insert yourself as early as you can, or else you really don't have much input in how it's shaped.
Yeah, and I guess on that point, I'd want to share, an example here of something where, touches on what Harrison talking about earlier about controlling dip rights. There was a situation earlier this summer where an offshore services company proposed an exchange. The company was sponsor controlled, and they proposed an exchange where unsecured bonds of the holdco were going to exchange into secured holdco debt. Terms of the documents were much weaker than they were under the initial unsecured documents. Including that, in theory, unsecured creditors, the existing unsecured creditors wouldn't have dip control rights, whereas they arguably did beforehand. A group of unsecured bondholders went to the company and said, "We don't really like the documents that you guys have proposed. Please tighten them to what they were, or we're not going to participate." And the company essentially said, "We're not going to make any changes. We're going to ignore your request, and we're going to proceed." So unsecured bondholders withheld their consent. They didn't proceed on the exchange, but at the same time they were doing this public exchange, the company, they were pursuing a private exchange with the actual sponsor. And so the sponsor also owned some of these unsecured bonds. The sponsor exchanged its unsecured bonds into these less favorable holdco secured bonds, and it created a really weird dynamic where now the company is sort of positioned so that the sponsor could really ignore these unsecured bonds for the next few years, and if the company's situation doesn't improve, in theory they could just flush the unsecured bonds that were offered the exchange and allow the sponsor to recreate their equity through this holdco secured debt. And so I think there's obviously an importance on controlling documents, but I think as investors we all have to be mindful of ultimately it's about P&L and where you are in the long term. On this situation, I think the very first trade after the public exchange failed and the private exchange was consummated, these holdco bonds were down 50 points. So there could be real consequences to insisting on tight documents.
It's interesting that holdco LME is something there's been a lot of this year, and it's interesting to hear that in that instance it traded down on day one. It does seem kind of unique to this environment. I think it's maybe a function of the fact that the borrowers still have an appetite for new money, new financing to carry them through until the full emergence of the pandemic. And a healthy appetite by investors to provide that even at a super junior level. So we've seen a bunch of potential LMEs where funds will pitch holdco level debt outside of the covenants of the restricted group. So it's just kind of an interesting trend right now, I suppose.
Okay.
There is Mark. Sorry, there's one thing we wanted to cover, which kind of keys into Mark, which is about how you challenge these.
Mm-hmm. Yep.
And one of the threshold questions that we always go through is whether you challenge these through the indenture trustee or you challenge them as individual bondholders. And I'm sure Mark has strong feelings on that.
Well, as an indenture trustee, we're often the last person to the party, if you will, not being involved in either the negotiation of the indentures or the years of what we used to call pre-bankruptcy planning or corporate asset redeployment, which is now litigation management. So we may be called in at the last second to offer an opinion and serve as the trustee for litigation going forward. And sometimes maybe we're brought in because of that lack of knowledge, but I don't think so. I'm not that cynical. The trustee in that situation has to often act very quickly and at first does sort of for the lawyers here, a Rule 11 type analysis about whether or not such litigation could be supported by the existing law in fact or a reasonable extension thereof, or to the extent they are appointed as successor trustee under the indenture, if there's a default that's continuing, they are sort of held to a reasonable prudent person standard. So there are protections obviously for the trustee in that situation, and they include pretty much standard language in most indentures are that the trustee can rely upon the opinions of its professionals, and that's a key, especially when time is short and the trustee's brought in at the last second. As I walked over here today, I saw the statue of General Sherman out here. Reminded me he had this quote that said of General Grant, Grant stood by him when he was crazy, and he stood by Grant when he was drunk. And that's sort of the relationship that the trustee has with its counsel. Not really, but the trustee enjoys great advantages to the extent it can hire and rely on its professionals. And so the key to the trustee's involvement at the outset is getting its professionals and having a separate professional, even though they sometimes share lawyers going forward, they have their own counsel to advise them. And that gets particularly significant when the bondholders are thinking about bringing a suit or the trustees bringing the same suit. In a matter I worked with Harrison on, Windstream, when we got involved in the case, there were several different tranches of debt and securities and bonds, and it was very hard to tell what each group was comprised of. On day one, we were being directed by a party who may have had controlling interests or in bankruptcy blocking interests in several different groups. But the trustee in that situation has to make sure that it's looking out for all the holders of its particular group, because the directing shareholder or the directing bondholder may not be.
So, Mark, I asked Alex and Harrison about the B word earlier. Do you want to talk about the I word a little bit, in indemnification?
Well, yes, I do. Recently, there was a decision in Neiman Marcus, which I think Harold or others will talk about later, but it involved a particular judge, a very important district, a particular indenture, where the judge determined that the trustee, to the extent there was no default under this particular indenture, the trustee had no standing to bring an action, and the action was dismissed. In that circumstance, the same sort of litigation continued through the bankruptcy and resulted, I think, in the same thing. In other words, a return for our bondholders. But to the extent that there is now a court or courts out there saying that the trustee may not have standing to bring some of these actions, it's very important that they obtain indemnification. And the indentures all allow and require that, so that's a very important part of the discussion with the trustee.
And Mark, what do you tell us a little bit how you approach it if you're not involved in a deal, but let's say a current trustee needs to resign because of a conflict of interest or whatever, and they just want to get out and they approach you and say, hey, here's a deal. It's got a little hair on it because there's this stuff going on. Give us an idea of like how you kind of look at that and how you might decide whether to step into that situation.
Yeah, quickly, we do, as I suggested earlier, a sort of a Rule 11 type analysis to make sure that there's a valid claim there. Then we'll go through the process of very careful review of the indenture and any related documents, and the Neiman Marcus case points out how important that is. Again, we don't have the ability to change those terms, and there's a large body of law surrounding what those terms mean, but it really starts out with just a careful review of the facts in the law, and in particular the indenture, and then obtaining separate disinterested counsel who can, we are allowed to rely on the advice of counsel for our complete protection. So those are the essential steps we have to take at the outset.
Okay, great, thank you. And let me just open it up a little bit to everybody, and just if anybody wants to kind of chime in on this. I mean, we've talked about kind of the steps leading up to, things that might happen leading up to a potential Chapter 11 filing. We've touched on Chesapeake a little bit, but can any of you talk to, once the company, these transactions don't work, let's say, the whole idea was to avoid a bankruptcy, but now we're in a bankruptcy. How do these issues play out? Talk about, the influence of a creditors committee, who's representing the committee, who's on the committee, ad hoc bondholder groups, anything about how this now all plays itself out in a bankruptcy case?
Yeah, I think like with everything else, it's incredibly fact specific. I think some transactions, the timing, the proximity of when those transactions occurred to when the bankruptcy occurred, the details of that transaction, did they arguably move value away from certain creditors? Did they layer certain creditors? I mean, that will sort of dictate, I think, how aggressively parties might go after those transactions and who will be the ones litigating with you. But I also think that it's often more of a negotiation tactic versus a true goal to litigate and have that the result of that litigation be your ultimate recovery. And I think it's kind of interesting, just sort of a sidebar to what you asked, but if companies just filed for bankruptcy without trying to undergo any sort of liability management transactions, I mean, arguably that could be the source of its own set of litigation around breach of fiduciary duty. It is not responsible to just say, we have a problem, file, and that's not what boards do. And if we advise boards to do that, we would never get hired again. So, it's just part of the process, I think, that companies go through. And so, I'd be curious to know how judges think about a lot of this liability management litigation, because, as long as you were doing this with good advice and proper process, and you thought it was going to take your company to a better place, there's business judgment protection, and that's obviously very good protection. So I think it ends up being a lot of noise over nothing, not all the time, but many times, but certainly something that occupies a lot of our time as restructuring professionals.
Anyone else have anything on that? No? No, I totally agree. Okay. Looks like we have about 2 or 3 minutes for questions. Does anybody have any questions for the panel? No? Okay. Well, thank you very much. Thank you, panel.